Hey, everybody, welcome to our very first episode of the still unnamed podcast. We have Omar Chaudhry, Will Moy. Our very first guest today is Shane Osborn. Shane has tried over 300 cases, 22 this year alone. We're only in June. Shane, how's it going?
Busy. Doing well.
So, Shane, today we're going to be talking about trial prep, right?
Yes, sir.
Speaking of which, you have a trial this afternoon.
Yes, sir.
What kind of trial are you trying today?
This afternoon, it's going to be a case about a tree blowing over during Hurricane Beryl on a neighbor's property, and they're suing for the damage that was allegedly caused by the tree.
Property damage only?
Property damage only.
So, obviously, it's starting at 1 p.m., so it's a bench trial.
Yes, it's a bench trial.
So this will be number 23 on the year?
It will.
So you finished one yesterday as well, correct?
Tuesday.
So we're sitting on Thursday.
Yeah. So 2 days ago.
Yeah. So, that takes us right into our topic here, trial prep. How do you do this? Two trials in a week?
Well, the most I've done in a week is 3. This was pre-COVID. They were all jury trials. And the way we do it is that you have to prepare. And the way you prepare is by following the proper procedures of doing discovery.
Well, there you go, folks. That's it.
Go try your case at 1 o'clock.
Yeah, go try your case. Yeah, you just have to prepare.
It's a little more complicated than that. But one of the first things that we teach all of our young associates, and we've hired 6 in the past year, is that you've got to read petitions. You've got to read the allegations. Those are important. You've got to look at what their disclosures are. Most people gloss over disclosures. They don't read what's in them. And discovery is the most important part of any case, because not every case is the same. They might be cookie cutter in the same, similar facts, but you have to read the disclosures. You've got to read the discovery responses and know what you're going up against, because every case is different.
Shane, I think it would be helpful for anybody who's watching this podcast or listening to this podcast who doesn't know who you are, which, if you're in the Houston trial lawyer circle, you know who Shane Osborn is. But can you tell the people out there a little bit about your docket, about your practice, why you are in trial so much?
Sure. So my docket consists of around 1,200 to 1,700 cases at any time. They are mainly third-party auto defense. And for those of you that don't know what third-party auto means, in Texas, if you're involved in an automobile accident, your insurance company would then hire somebody like myself or somebody like Will, formerly, when you were on the defense side.
I'm not taking that type of work now.
Well, right. Will's not doing it now, but back in the day, he did. And so what they would do in Texas, which is contrary to Louisiana, in Texas, you cannot sue the insurance company. You have to sue the actual driver who you allege was at fault. And so in Texas, we represent every major carrier in the state except for one. So if you're insured in Texas and you're involved in an accident and you get sued, your insurance company would then hire us to defend you. And so that's the majority of our work. My work. Now, our firm does
everything under the sun.
Yes.
And you're with Martin DeSeer, Jefferson Wisdom, correct?
Yes, sir. That's correct.
Old, long-standing firm here. Great people.
Chris Martin practically wrote the insurance code. David DeSeer did the same thing. They love first-party work, meaning they love representing insurance companies.
Right.
You used the magic word, first party versus third party. When it's third party, who's your client?
The insured,
exactly.
The individual.
Exactly.
I do not represent insurance companies.
Exactly. And you said you do have 1,200 active cases at any given moment, roughly. How big's your team?
Right now, 32.
Lawyers and paralegals, legal
Correct.
assistants?
So 16 attorneys and 16 paralegals, legal assistants.
Okay. And you're kind of like top of the
it's a pyramid.
Myself and Chris Graham.
Okay.
So Chris Graham is my partner who manages the entire team. So I would say we're at the top.
Yeah.
And I try the cases. He manages the day-to-day.
Because that's my question. So if you're in trial, as much as you're in trial, and trying a case to a verdict or to the bench, one thing. Getting ready for trial, showing up to trial, settling in the hallway happens too. So you're in the courthouse with 22 trials. You've actually probably went to go start a trial times 3, 60 times maybe?
I don't keep track of that number.
Okay, but it's a lot.
It's a lot.
You're
And
not going through discovery responses and saying, golly gee, let's make sure this was answered the right way.
That's correct. That would be Chris Graham monitoring our entire team, and Chris does an amazing job doing it.
Okay.
So he handles the day-to-day.
And so, like for younger lawyers or whoever, really, it's a grind. I mean, you need a team to be able to do this.
100%. And we've got 3 interns right now, and law clerks. They're, I believe, all 2Ls at, I think 2 of them are in South Texas, one's at U of H. And we're trying to teach them the proper way to do things. Because one of the things I've always said is that I would rather hire a brand new baby attorney to teach them the right way to do things than hire somebody who's been practicing for 2 to 3 years and retrain them, because a lot of times people are not taught the right way to do things.
You know how unique that is? Universally, and someone that was at a big defense firm that was always hiring because we were always busy and always needed help. No one wanted to invest and mentor a baby lawyer. They always wanted that unicorn of a 5th-year revenue generating, know what they're doing, can run a file by themselves. We can all make some money off their hard work.
And we're the opposite.
Yeah.
Because it's so hard to break somebody, and we've seen it. We get, letters saying, why did you object to XYZ? And I go and ask the associate, I go, when they include me on it, I know there's a problem. I don't get included on a lot of emails for a reason, because I don't ask to be. And there's a reason why we do things the way we structured it. So when I'm included on something, I know it's an issue. And so going to an associate who's worked somewhere else for 2, 3, 4 years and ask them, why did you object to 24 of their 25 interrogatories? What was the basis? Well, that's how I was taught. You object to everything. And I'm the exact opposite way. You answer the question. We're not going to be obtrusive. We're not going to try and hide the ball. If the facts are bad, the facts are bad. Why are you going to try and hide it? They're going to get it in a deposition anyway. So treat things as if you were in front of a judge, would you be willing to stand by these objections? And they always would say no. Then don't do it.
Yeah, which we appreciate on the plaintiff side, because I try to preach no objections constantly, but sometimes you have to, obviously. But
if it's a bad question, I get that. But just objecting because that's how you were taught, that's not one of the things that we teach at all. And I think it's a very bad way of practicing law.
Forms and cut and paste
Right.
results in too much boilerplate nonsense that's not responsive to what's being asked, and it doesn't help you out. And then the problem is your form and cut and paste sometimes results in very bad answers in our responses to interrogatories.
Yeah,
Exactly.
That when you're walking in the courthouse, then hand you that notebook the day before and say, that's not a good interrogatory response.
It will come back to bite you 10 times harder than what you think. And so we try not to do that.
And like you said about hiring or having law clerks with the intent of hopefully they're good and bring them on as first years. Our firm, we just recently did that with 2 they're graduates now. They're taking the bar in July, but they've only worked with us. They know our style, and like day one, they're going to be able to hit the ground running, which is, I'm looking so forward to it. They're rock stars already. And so I think it makes a world of difference. They know your style. So you're not spending the first year of their license training them.
Well,
That's unique. Y'all realize that's unique.
Yes,
So
it's awesome.
I remember my very first internship was at, not really a solo. It was him and one other attorney. And it was me. He did mainly work for subcontractors pursuing M&M liens. And I walked in on the first day, sat down. I meet the other 2 clerks, and he goes, Shane, I need a complete set of discovery. I need RFAs, RFPs, ROGs, and RFD. I go, yes, sir. And I turn to the intern, the other one next to me, and I go, what the hell is that? Because they don't teach you that in law school. They don't teach you how to actually practice law. And so that's one of the things that, at least for this podcast, I wanted to bring out was, how to actually practice law, what it means to send discovery, and how important that is, because that's what shapes the entire case. And knowing those things, you're not taught that in law school. I don't know of a single class. I mean, at least in South Texas, I'm not aware. And you went to
Seton Hall University,
Yeah.
and I didn't know what discovery was when I was in law school.
Right. Yeah. And I didn't either. It's one of those things they don't teach you. And that's in my opinion, one of the most important aspects of any case, that knowing your client.
Not a jaded question by any means, but the view of some defense firms that have a volume practice would be just get it out, because that's a 0.8, meaning they build 0.8 of an hour to send that out via associate or legal assistant. How do you guys then say, that's silly, we're going to make a bespoke, fitting the case set of discovery?
We do that on every case. It's not the same cut and paste, and that's one of the reasons why we have so many clients, is because we're not a cookie cutter firm.
You don't ask their favorite color.
No. we do things tailored to every individual case. Now, are 75 to 80% of them the same thing? Yeah, probably. But we take the time to actually look at each individual case because they're not all the same. And so it's that initial time of investigating the case, finding out the facts, talking to our clients to see what is different about this case, if there is anything different. And so we do tailor discovery based on each individual case, because that's how you win cases. You win cases by getting the right answers to questions that most people don't ask.
You said talking to clients. Again, you know how infrequent that is in a volume practice where a defense lawyer never talks to their client?
We require it within 24 hours.
Okay.
Of getting an assignment. We are required to make contact with our actual client, not the carrier who sends us the case, but we make contact with the individual client because that's our client. Yes, the insurance company might be paying the bill. They're not our client. I might get in trouble for saying this. I don't care what they say. They're not my client.
Well, you can't. The beauty of it, because you're not worried about that. You have a business relationship with the insurer. It's an important one. The firm matters, but your ethical obligation exclusively under Tilly is to
100%.
The insurer.
And my only concern is that actual client. And so the carrier who sends us the case, they do not dictate how we manage the defense. They don't get to say anything about how we handle the case. And I've gotten pushback from that, and I've fired clients for it. I fired carriers saying, you do not get to dictate what is in my client's best interest.
And you've earned that right by, practicing for as long as you have and trying so many cases and being successful on the defense side.
Correct.
Yeah.
So Shane, I'm going to give you a little pushback. Not pushback, but if a HTLA member is listening to this and they go, okay, Shane, I just heard Shane say, let's be reasonable. We're not going to object to anything. Where do you fight? Because I'm trying to get that out of you, because I know where we fight. We've seen you in trial. We've been on the losing side of a Shane Osborn case before. Where do people misunderstand you? Where does the misconception of Shane Osborn, the big bad guy, come from? The prick. Where are you fighting?
That's a very nice way of putting it, because I've been called much worse. Most plaintiffs' attorneys think that I'm just working for an insurance company, and I'm not. I work for individuals. And so when I'm in trial, I'm fighting for my individual client. And so they, most of the time, don't think that's the case. So that's the common misconception, is that I'm working for a multi-billion-dollar insurance company, and that's my only concern. That's not my concern at all. My concern is my individual client. And so when I'm at trial and I am fighting, and I do fight at trial, I will fight tooth and nail for my clients. The reason I've got such a, I guess, lack of a better word, bad reputation, is because I fight. And I fight on the law, and I know the law, and I read every opinion from the Supreme Court that's issued every Friday. I read every opinion from the 1st and 14th that are issued on Tuesdays and Thursdays. And then when I show up to trial, I've got trial binders of just case law. And so when a plaintiff's counsel is saying, well, this can't come in, and I hand the judge 10 copies of other cases that say, well, they're wrong, that's not looked upon favorably by plaintiff's counsel. And so I want the facts to be heard. I want the jury to see the facts. A lot of the fight is over attorney referral, who referred you to this facility, and photographs. A lot of times plaintiff's counsel do not want photographs admitted at trial. And I've got case law from the Supreme Court of Texas and every court of appeals that says it's an abuse of discretion not to admit them. And they don't like that.
And you're talking about photos that show little to no property damage.
Correct.
How do you get it in? Not foundationally, but what's it used for? Like, do you use it through a doctor? Do you use it through a witness? Or are you just trying to get an implication? The jury goes back in the jury room and says, no PD, no injury? Like, how's it come in?
No, so I've never said no PD, no injury. That's not a mantra that I've done. Some
No
judges,
property damage, no injury for the non-lawyers watching this.
Correct.
podcast.
Sorry. Yes. So no PD, meaning no property damage, equates to no personal injuries. I've never said that. I don't abide by that. I don't believe that's true, and I don't believe any expert would ever say that. One of the things,
There's some folks in San Antonio that will say that in every case they're hired on, but go ahead.
I disagree with that. I mean, people can be injured from minor impacts, and then you see people walk away from a car being totaled that had flipped 5 times, and they're totally fine. Those two things do not equate. I've never argued that. I don't say it, and any expert who does, I will never use. And so, one of the things that, at least from the Supreme Court, has said, photographs involving an automobile accident are entirely relevant, and they are. Right? I mean, every jury wants to know if the photographs don't come in, and there are some judges who luckily are no longer on the bench who would not let them in absent a biomech. And so we had to start paying for a biomech just to get them in. But every jury wants to see photographs of the accident. How is it not relevant? You're suing for tens of thousands, hundreds of thousands, millions of dollars from an automobile accident. How is it not relevant to see photographs of the accident? And so that's the main common sense argument, is every juror wants to see these. Can you think of any other scenario where you would be suing for hundreds, if not millions of dollars, and say, we don't want to see any photographs or videos of the allegations that you're suing upon?
I understand that. And I get that jurors would like to see, what was that crash? What did it look like? But at the end of the day, that argument that we hear so often, you might not make it yourself, but no property damage means there couldn't have been an injury, and I think people try to say, oh, I've run into a pole, I've had more damage than that, I wasn't injured, and I think that's where that fight comes, is because they're starting to use this, something they're not supposed to use, their outside knowledge of what may have happened here, and I think it's prejudicial sometimes.
Well, everything that I want in is prejudicial for y'all's side. I mean, literally, everything I want in is prejudicial to y'all, and everything y'all want in is prejudicial to me. That's not the standard. Is the probative value outweighed by the prejudicial effect? And to me, the prejudicial effect is showing the jury the photographs. I agree 100%. Yeah. Anybody who says because there's no property damage, there can be no injury, that's just a falsehood.
What are the other fights? So pictures, police report,
doctor-driven LOPs.
Doctor-driven LOPs.
I don't get into LOPs. Just personally, I don't. It goes over jurors' heads. I don't mention LOP. I never do, and I never will, because jurors don't understand it. So I will always agree to every motion in limine about excluding any type of LOP referral, because jurors don't understand it, and it doesn't do us any good. Now, one thing I will fight about.
Mine is rather self-serving, so if anybody wants to put mine in evidence, they're free to.
Well, and
that's the way it should be.
One of the best,
I've seen. Hold on. Can we pause this? I think I know where you're going with this, but does that mean your LOP has language that says, because the insurance company is failing to pay?
It is very self-serving.
Yeah. Yes. Okay. So for anybody listening, this is a good tip.
Yeah. So obviously for the non-lawyers, letter protection meaning, and look, as a former defense lawyer, I used to raise some hell about LOPs too. The very first, not a war story, but the very first case I had of a significant rear end Delta V in the 30s truck accident, had a client, ER, actually ambulance at the scene, ER, next day called me. I said, go see your GP, use your insurance. And they said, they won't see me. I said, what do you mean they won't see you? I'm like, they won't see me. And I had no idea this existed as a phenomena on the plaintiff's side.
Yeah.
So then I said, well, I'm going to help you get the help you need. Here's a selection of people that I know and trust, because I was against them when they were, when I was a defense lawyer and the plaintiff's doctors. And I'm going to send an LOP. And it largely reads exactly like Tommy mentioned. These folks won't stand up and be accountable. These folks are making them spend their deductible. These folks are making them spend their, what do you call it when you owe money? When you go copays. It's like, why did my folks got to pay copays for the next 2 years and pay a deductible on their health insurance for 2 years when they got rear-ended on the highway? and the truth of the matter is because that's what happens.
And it's amazing how much you get turned down after telling them you're in a car wreck.
Yeah. If anybody wants to put my LOP in evidence, they're free to, because it'd be heavily redacted outside of my logo.
Right. But just from a trial, from a standpoint of practice tips for any plaintiff's lawyers who might be listening, or any defense lawyers who might be listening, because we want this podcast to be for everybody. But it probably makes sense from the plaintiff side to go above and beyond
100%.
on your LOP, rather than just saying, hey, I represent this person. Take this as a letter of protection. Any funds that we get out of a settlement will go to pay
They can
you.
be factual, but they can be argumentative.
Right.
And it goes to what Shane said earlier. Don't just cut and paste and do things that are more nimble and more bespoke.
And it won't even affect Shane at all, because he doesn't even argue about motions in limine for LLPs.
Exactly.
So you don't fight on LLPs, but what you do fight on is attorney-driven, when the attorney drives the medical care, allegedly.
Correct. Especially when we have proof that there's emails between the provider and the attorney that say, we will not perform this injection without your approval, and the attorney has to approve the treatment that's being sought. To me, that crosses a line, because attorneys should not be dictating what treatment any individual gets. And when that happens, I want the jury to hear it, because in my opinion, that's unethical. I don't know how it's allowed, but it happens. And so those are the things that I fight for, is pointing out to the jury that all this treatment that this plaintiff received was driven by this attorney.
Can you walk us through what a general fight like that looks like? I mean, so obviously this is a very hotly contested thing in pretrial. So you come with your binder. You have your case law.
The only case out there that says attorney referrals aren't allowed is a dissent from the Supreme Court, where the majority said it's entirely irrelevant. And so every plaintiff's firm out there will cite the dissent and saying, well, this is not allowed.
So you're citing the same opinion.
I cite the same opinion by saying the majority disagreed with this one dissent.
But there's one case.
Yeah. That's it. There's one case.
And sometimes you win, sometimes you lose.
Sometimes I win, sometimes I lose. But I would say 90 to 95% of the time, I get it in anyway.
Have you appealed the issue ever?
No.
And I was just curious because, that there's one case out there. I'm sure someone will at some point.
Somebody will at some point. The other big fight right now is on meds that are stale, right? You haven't paid anything. These bills were never sent to you. They were sent to your attorney. And now we're at trial 6 years after you last treated. And so there's a big argument, and I think it's pending right now in front of the Supreme Court. I forget the case name, but these medical bills are more than 4 years old. You don't know them.
Yeah, walk us through, because that has been a hot topic of conversation. And I know you were kind of not the forefront, but you were one of the first defense attorneys to go out there and start arguing that they shouldn't enter these bills because they're over 4 years old.
But couldn't you make an argument that the statute of limitations doesn't actually start until the case is resolved?
That is an argument. But here's my question. I've got a great appellate team. I've got 2 board-certified appellate attorneys who are phenomenal. They did some research, and there's actually a different argument that I make, which is the finance code. The finance code requires the bills to be sent within 11 months of the last date of treatment to the individual. That's never done. They're never sent to the individual. They're sent to the attorney.
But do they need to be sent to an individual when there's a letter of representation saying, hey, any communication, I'm their lawyer.
I'm their agent.
That is a very valid argument. I don't disagree with that.
All right.
It's an argument.
Mark that down. What time was that on the clip?
Yeah.
We might need to cut that.
I get your point. Yeah, look.
But you're an advocate. As an agent for your client, is it valid? That argument is being made. But so our argument's a little bit different. We say it's 11 months, not the 4 years. Regardless, the 4 years, they admit they've never received a bill. How is it owed? And the catch-22 of that is, why do they want it to be owed? And so the way I use it at trial is, why are you arguing to owe money when you can say, I don't owe a dime? Well, the reason why is because this attorney sitting right here wants you to award as much as possible.
I envision some plaintiff's lawyer listening to this right now, just
rolling their eyes.
rolling like smoking a cigarette. This guy, pacing up and down their hallway.
What's the legal basis to say they don't owe it? Is it?
It's more than 4 years.
But what's that? Statute of frauds?
Statute of limitations.
Statute of limitations.
For the breach of contract.
Contract. It's 4
What
years.
if they argue they haven't breached? That they're deferring their receivables to allow an outcome.
Well, then
And there's been a universal agreement between provider
then I
and
get
patient,
what I want.
which is
The jury hears that there's an agreement
between the plaintiff and the
between the plaintiff's
Provider?
attorney
Yeah.
and the provider.
what do you?
So I get what I want either way.
What do you do when you have someone that cannot afford that type of medical care, lacks insurance, and the lawyer stands up and says, "I helped them
Then
because
be
my
honest.
job is to help them." And
I
the client
agree.
takes a stand and says, "I had nowhere else to turn but my lawyer. He or she guided me in the right direction. I am better now because of the medical care they helped me get."
I lose those cases.
And have you noticed that when plaintiff's lawyers stand up and they just own the bad facts?
I lose those cases.
Yeah, because it's transparency with the jury.
Well,
Exactly.
I mean, I can just say from personal experience, Shane is the master at owning bad facts.
Yeah.
I mean, you're very curt. You just get up there and it's almost disarming.
When do you do it? Opening or do you season that
Opening.
blood hour?
No. Oh, well.
Can I? Oh, I'm gonna do well. If Shane allows this, I'm about to perform Shane's entire voir dire against our case, starting now. Ladies and gentlemen of the jury, thanks you. That was a great 3-hour conversation by my plaintiff's co-counsel. I have a question. Can anybody raise their hand if your back has ever hurt? Okay, thank you. That was Shane Osborn's voir dire.
Depending on the case, yes, I try to be brief because jurors, even potential jurors, appreciate brevity.
Oh, yeah.
And by disarming them with, this is a very simple case. Yes, they just spent 3.5 hours asking every question under the sun. I'm not concerned about it because I know the facts are on my side, so I'm not going to waste your time.
You know, we talked about transparency with the jury, and I bring this up because I was trying a case a few years ago, and I was telling my wife, like, you know, I just wish you could tell the jury that there was insurance. Like, I'm not trying to take money out of Shane Osborn's pocket when I'm suing him.
But they know that because the court's instructions say you cannot consider insurance.
Instruction number 9.
By saying that, the jury knows there's insurance.
But that's not until they're actually seated.
That's true. And then the little old lady who's, being sued, but as a defendant, one of your clients in a big case, but there's, a $50,000 expert here, a $50,000 expert there, a $50,000 expert there. And the jury's like, she's not paying 150 G's for these 3 experts who came in.
You would hope that happens. And sometimes, like, we've gone through and they're like, you're kind of hinting at it, whatever. And then jurors are like, well, I thought there would be insurance, but I guess not, since they're not mentioning it. And I was like, don't you think it's somewhat unfair that it's not mentioned, that you're sitting there acting like, oh, they're going to try to take money from this poor little lady?
Let's play catch-22 here. Would it be fair if we were to say there is insurance and they had a minimum policy of $30,000 and you're suing for over $1 million?
Someone might say also collateral source would be thrown out. And then every time a client who had health insurance chose not to use health insurance for whatever reasons, that would be equally admissible universally.
No, I agree. I'm not saying.
My prediction is our friends don't want that to occur.
The law is what it is for a reason. And it's just sometimes it's so, I don't know if you go through, I've never tried a case against you, Shane, and I don't know if we will, but maybe down the road we will. But when you're sitting there, do you ever go through and make it sound like we're beating up on your little old client here?
I don't ever try to insinuate that any verdict or judgment would be against my individual client because I think that's just improper.
Yeah, I agree with that. I've had that happen.
I will hammer the fact that you're asking for XYZ. You're asking for $1 million against this individual, but I won't ever say that, that they're going to have to pay it because 9 times out of 10, it's just not true.
I did it once and didn't get an objection in closing, but it was a punitive ask for $15 million. And during my closing, I stopped, turned to the client and said, by the way, you got $15 million? And it was just like, he's like, got eye struck and clearly objectionable, but did it anyway. And it worked.
Well, yeah, I
it
mean,
was punitive. And I thought, well, that's not covered anyway. Not that we're getting the insurance.
that's how you
stuff,
sell
right?
it. You didn't rehearse it.
Didn't rehearse it.
Yeah, it was
I just
genuine
spun around
shock.
and said,
Yeah.
you got $15 million. And his eyes popped out of his head. It was
You end up
perfect.
winning.
We did, actually.
Yeah. We said this show or this podcast was not going to be war stories, but I do got to hear about one trial that sticks out in your mind where you were going through and something just crazy or that won't ever leave you that happened.
Federal court here in Houston, Judge Bryan, magistrate judge, head-on collision. My client admitted to crossing over the center line, causing the head-on collision. It was raining. He was driving a 2500 Chevy, 4x4.
For work?
No.
Okay.
He was here. He actually played baseball and got drafted by the Marlins. And so didn't even appear at trial. And I just read his depo. So didn't even appear, caused a head-on collision, sent both plaintiff and the passenger to the hospital, settled out with the passenger for limits of 100, had another 100 on the table, and they wouldn't pay it, fought tooth and nail. Jury comes back and says no negligence.
Because of the rain?
Because of the rain. And that got appealed to the Fifth Circuit, and the Fifth Circuit affirmed.
There you go.
Wow.
Because-
Fault doesn't mean negligence.
Correct.
In the words of, I
I know y'all hate
disagree.
it.
I
Every-
disagree.
And I even had Judge Kyle Carter. He's I respect him. He's a great judge. Rear end accident. My lady was driving a Hummer and she plowed into the back of one of those small, not like a Prius, but like one of those smart cars, and just totaled it. But it was raining. She slammed on her brakes, and he granted a directed verdict on negligence. And I said, Judge, don't do it. I said, I've got case law right here that says you cannot do this. He disagreed, granted a directed verdict on negligence. The award was small, like $60,000, and we appealed just to send a message. And he got reversed, saying you cannot do this. Admitting to causing an accident does not equate to negligence.
Okay,
And
but
I know you're breathing deep and you're sighing, you don't like it, but that's the case law.
I think the case law can be wrong sometimes.
Well, we just won an appeal
Okay.
where the 14th court took it en banc to reverse a prior decision where they determined that a rear end accident was
I
negligence.
know. That's how you beat us. Remember, it was a rear end accident case. You got a no fault.
It's
Well,
a simple argument.
It is.
I mean, it really is. It's effective.
But okay, if negligence means what a reasonably prudent person would do in the same or similar circumstance,
That's
what
it.
you're saying is, if somebody crashes into somebody, I choose to believe that I want to drive on a road where crashing into somebody, a reasonably prudent person wouldn't do.
I can just see you you're losing your shit right now.
I know. This is supposed to be an unbiased podcast with both sides of everybody. I know. That's the point. And that is why you're here, Shane. That's why you're our first
Wasn't
guest.
there, you
We
got to
wanted
read
you.
opinions. So Saturday or Friday, Supreme Court, did they not come out with a good for you, bad for us, unavoidable accident opinion? That essentially
they did, yeah.
largely
Yep.
says now
Yes.
we have the burden of proof to
Yeah.
prove it wasn't unavoidable.
Yes.
We meaning the plaintiff's bar.
Yes. They
friends in
reversed.
Austin.
It was El Paso that they reversed and sent it back and said, sorry, you get nothing. We're affirming the summary judgment because they didn't put forth evidence of negligence on that case, it was two 18-wheelers, right? So the 18-wheeler that was being sued had a tire blowout, and therefore he was crossing both lanes. I think it was here in Houston. Well, it was in El Paso, I'm not sure, but the accident was here in Houston. Crossed both lanes of traffic and stopped. And the plaintiff plowed
I was
into
doing
him.
my venue analysis.
Yeah.
I'm like, why would you file in El Paso and you can file in Harris County? Go ahead.
Well, I think of a couple reasons. But regardless, they didn't produce any evidence that what the defendant did was negligent.
I mean, how did they not produce any evidence of it?
They produced a ton of evidence, but nothing showed that he was negligent.
Wow.
What did he do wrong? His tire was properly inflated before he got on the road. He checked everything else. He had a blowout. Actually, that's the problem that, no offense, so many plaintiff's attorneys don't realize. Accidents happen.
Yeah, that's what causation is.
I mean,
you got to prove causation.
And so
Standard of care and causation.
he had a blowout.
Tommy's point, the standard of care is don't drive like a lunatic and crash into people on the highway.
Tire blowouts are a little different than a rear end. I mean, I could see how.
So the Supreme Court case you're talking about, that was a tire blowout on an 18-wheeler. So it's a little different than a rear end accident. But again, the one thing that I stress is accidents happen.
Yeah.
You're a reasonably prudent driver. If you think you're keeping a safe distance, you see somebody in front of you apply their brakes, you apply your brakes, you just can't stop in time.
I lost my first ever trial, I think was 2015, 2014, and rear ender. And it was Michael Simcoe. And he said, just because this guy admitted to fault, he dressed him up in his Army gear. He was a 18-year-old kid that just joined the Army. He's like, it was my fault. I 100% take fault. And he's like, fault is not negligence. And came back with a 0 negligence.
Well, I mean, if it's an injury causation case, that's what you do often.
Yeah.
Yeah, we caused the accident. We admit causing the accident. We didn't cause the injuries, or the accident didn't cause the injuries. You can try the case on that issue, and you still get a no negligence because you got causation as part of negligence.
Yeah, I mean, I say best ones for us. On the defense side, the best ones are when they answer the first question no, and then still write in zeros for all the damage questions. Because how are you going to appeal it?
Yeah.
That just kind of sends a message of we don't believe a single word that your client said.
Hey, tell me about trial tech, knowing that jurors like to see stuff. They get kind of a CSI concept. They want to see it. Like you mentioned pictures. It doesn't just stop there. I mean, there's a lot of depots and testimony. We put them in a church pew for 7 hours a day without cell phones. And, we got to do something to keep them entertained. Are you a trial tech guy or not?
I am not. I'm more old school. I understand that
Elmo.
I'm Elmo, right? I'm a paper guy because to me, I'm still of the opinion that physical hard evidence is something that people want to touch and feel. So it also depends on the age of your jury, right? I mean, if you've got a jury that is under 30 years old, they're going to want to see the CSI type of things. So in that scenario, then I will employ a different tactic based on the age of the jury. But if my average juror is 55 years old, I want the paper. I want to hand them, hey, here it is. You can feel it. You can touch it. You can look at it because that's their mentality.
Do you hand it to them in the box?
Absolutely. Yeah. I mean, I ask permission, of course,
Yeah.
from the judge. Your Honor, permission to publish to the jury, whatever.
You bring 12 copies?
Back during COVID, we had to bring 14.
Oh, yeah.
I mean, you had to have separate binders for every single thing because everybody was concerned about touching things.
Yeah.
And so now I don't. And the best argument I have, and I'm probably giving away the farm here, is plaintiffs on exhibits. Using their own exhibits against them.
Well, you use medical records.
Right.
I mean,
I go through every single page of every single document of everything that's ever been produced, and I will use your own exhibits against you. And there's no way around it. Y'all can't anticipate what I'm going to do because 9 times out of 10, even if you could, you can't somehow fix it.
Yeah, and so, looking at it, plaintiffs' medical records are always chock full of inconsistencies, or they're written down wrong, or and you probably know they're written down wrong, but what it says is what it says, and you can use that to just destroy a case, right?
Exactly.
Yeah. And that's where, do you consider that a lot of your success comes from?
Yes.
Medical records?
100%.
Yeah.
By pointing out inconsistencies that cannot be explained. And again, I don't want to give away too much, but I normally wait until closing to do it.
Yeah.
That way there is no way to walk it back.
Because you're in evidence already.
It's already in evidence. Yeah. And so by pointing it out and highlighting it in closing, you don't get a chance to explain to the jury why it says my left knee hurt instead of your right knee when you had an x-ray on your right knee. And so it's things like that I will wait and use in my closing arguments, and there is no way for you to walk it back.
If you're not a tech guy, have you seen your adversaries use tech effectively? And I'll be honest with you. We tried a case a few weeks ago, and we did animations of surgeries, and I thought they were compelling. I thought they were awesome. I think with, our Gregory Chohan issues about nature, duration, severity of injury, I think it's showing what happened, how it works, I think it's compelling. Have you seen anything while you might not use it, the other side used that you thought was particularly effective? Since this is a plaintiff and defense show,
I have seen it used. I think it comes down to whether or not they believe your client.
Yeah.
And so it doesn't matter how many great animations you've got or 3D images redoing an ACDF or, a cervical fusion, showing exactly what happens. If they don't believe your client, it doesn't matter.
do you think though that sometimes they give the benefit of the doubt if surgery's done versus surgery's wrecked?
Oh, yes. Surgery recommendations, I could probably count on one hand out of the 300 trials where it's been awarded.
No.
Because the problem, at least in Houston, in Harris County, is so let me get this straight. This surgery was recommended for you back in 2019, and we're in 2025, and you still haven't gotten it. But you're asking the jury to give you $150,000 for it when we already know you haven't paid a dime for any of your treatments.
That's it. Because it's, well, I get it if I could afford it. Well, wait a minute. You haven't paid for any medical yet.
Right. You haven't paid for anything. And so I have not seen that be successful.
See, your key is expedited trial settings.
Well,
That's what you're trying to tell me here.
What I'm saying is it's a hard pill to swallow to convince anybody who you haven't paid for any of your treatment. And the reason why you haven't gotten this surgery that was recommended 6 years ago is because you can't afford it when you haven't paid for anything.
That's the problem with life care plans too. I mean, if you got an expert deadline, you got to give a life care plan. You don't try the case for 2.5 years. And the first thing the defense lawyer does is let's go through and itemize all the things you did on this life care plan. Nothing. And it's a problem.
The wheels of justice turn slowly.
Yeah.
It's a common kind And I kind of want to go back to what you were saying though, when you're pointing out inconsistencies, pointing out that you haven't got this treatment, but have you noticed that if the plaintiff is just well liked, that the jury will find a way to award them monetary damages?
It depends.
Yeah.
It depends on what you mean by well liked. I've had some plaintiffs who were female and very attractive. And so I specifically then would choose jurors who were not. Just a nice way of saying somebody who might be a little overweight.
You get a Batson challenge of the unappealing.
That is not a Batson challenge.
Unappealing.
New protected class coming out. Yeah.
So
you only sat the ugly people. Well, and so I've had it backfire where you hear a very attractive stay-at-home female mom who's complaining and wanting hundreds of thousands of dollars. And you then have somebody on the jury who's got 3 kids as a single mom and works 2 jobs. And saying, well, let me get this straight. This stay-at-home mom's asking for hundreds of thousands of dollars and I'm working 2 jobs to, help just get my kids through life. And, so I've seen it backfire.
Yeah.
So I've not seen it be successful of an attractive an attractive plaintiff persuading a jury to give them more money because of their physical appearance.
Well, I've seen more like just they present well, regardless of what
Just
they're
likable,
attractive.
not attractive, but likable.
Likable, yes.
Yeah.
If you can get the jury on your side 100%.
Yeah.
I mean,
The inconsistencies don't matter then as much.
The magic word is credible evidence.
Yeah.
Right.
If it's credible, it's believable, then you win your case. If
The
you don't
people-
have credibility and believability, you don't win your
And I'm-
case.
Shane,
Again, go ahead.
I was going to say, can we stay on the topic of your jury panel?
Sure.
Is it case specific, or do you generally have a philosophy going into a case like, hey, all right, I know in an automobile case, if the plaintiff is a woman, I want women on the jury, or who are you looking?
Do you always favor the unwashed?
One, the very first question you asked, it's 100% case specific because every case is different. And so anybody who has an idea of, well, this is what I want for my jury, in general, I just think that's wrong because everything is case specific.
What do you mean? Like, no engineers, no doctors, no teachers, the
so-
old school
so-
metrics.
Right. So defense attorneys, they don't want teachers. They don't want people who are sympathetic. And plaintiff's attorneys, for the most part, y'all don't want engineers and accountants and people who are just black and white. I mean, that's just a general mantra of, in general, I think we can all agree that you guys, y'all don't want that and we don't want that. There's caveats, though, to all of that, right? I don't mind a high school teacher. A high school teacher doesn't put up with bullshit. And so I don't mind. Now, an elementary school teacher, right, they're going to be more sympathetic.
Yeah.
And so it really does
fair.
depend. So there's never a cookie cutter answer of I always want to exclude X, Y, Z, because it really does depend on the facts of the case.
Do you use a consultant?
No.
Have you ever?
Yes.
No.
I depending on the amount of exposure. I mean, if I've got a $50 million case, yeah, we're going to have jury consultants.
You're going to focus group
Right,
it.
we're going to have a focus group. We're going to try the case 3 times before it ever actually goes to trial. So yeah, again, it depends on the facts of the case. So it's really hard to answer your question because.
But you grade the veneer? Like I grade the veneer. Leader positive, I want to keep. Follower positive, I'll deal with. Follower negative, I'm probably getting stuck with. Leader negative, I got to fire my preempts or for calls as many leader negatives as I can get.
Yes.
Is that, I mean, do you have some sort of universal
I
metric?
have my own system that I use, and no offense, I'm not going to tell you.
No, that's fair.
Mine's a Bob Swafford leader
Yeah.
positive, leader negative concept. So I stole his.
When you go and try a case, let's say it's a minimal policy case that you're trying, do you typically have someone with you?
No.
Okay.
Why aren't you taking these young kids and these interns and
Correct.
these young associates?
I will take
Get them out of the salt mines, take them to the courthouse, sir.
I will. So if they're available, I will take an intern. I will take a young associate. I will take somebody just to observe to see, okay, this is why we make the sausage and here's the end result.
Yeah.
And so we always want them to have that experience. And that's why I implore every judge to please live stream, because it's so much easier for them to watch sitting at their desk. Hey, I'm about to cross this expert, jump on for the next 30 minutes.
We have the live stream running in our office all the time.
It's awesome.
We're flipping
And
through.
so, yeah, I mean,
everything.
I really appreciate every judge out there who still does it because it's invaluable.
And who else watches it? Mediators watch it. And mediators get a feel for
Right.
how cases are going, how
Other
judges handle stuff.
attorneys watch it. I mean,
All the time.
it's a great teaching tool. And I know it's a pain for the judges to have to do it because then you got to worry about turning it off for minor settlements and other things and stuff with protective orders. And I get why some don't want to do it, but I would implore every judge to please start using more live stream just so the benefit of teaching.
And it's actually funny because the last case I tried with Steve and Kevin, we sent the jury out, we closed, they sent back, and we're sitting there shooting the shit at the counsel table. My phone lights up 5 text messages. You guys are still hot mic. Like, hey, you're getting close. Like, turn it off. And so the first thing we shut up, and I was like, bailiff, can you turn this off? But I think that's also part of it because sometimes you just forget. It's so second nature that you just forget it's there.
This is the one thing that I would implore to anybody watching is that people think that just because we're representing one side, we have to be adversaries. We're not. I mean, I'm more friends with plaintiffs' attorneys than I probably am with
No, I'll go on record and say we're friends. That's why I can be mean to you.
Right.
We're friends.
And so I the one thing I can highly recommend is regardless of what side you're on, be cordial, be nice, and so you can be a zealous advocate for your client, but at the end of the day, I will always offer to take the other side out, regardless of who wins, for a beer afterwards. Like, let's go grab a beer and discuss the trial. Tell me what you think I did wrong. More than happy to do the same. Just to have that type of camaraderie of knowing that we did our best for our clients, but we don't have to be assholes at the end of the day. We can still all go out and have a beer.
Yeah, you're going to see them again.
Right. Exactly.
You're going
see them again.
You hope not to represent that individual again.
Right.
But you're gonna deal with this, and the bar is small in Houston. We have a lot of lawyers, but it's a small community.
It's a tight-knit group, and one of the things that I've stressed is if any attorney reaches out and says, I need a Rule 11 agreement because I screwed up, I missed this deadline, whatever, you give it to them, right? Unless they give you a reason not to. And I tell everybody on my team, I go, you're not allowed to be an asshole. I am. You're not. I said, so if somebody does something that you think was inappropriate, you come see me and I'll determine with the appropriate response. But just, I just wish in general, the bar would just get along.
Live
right?
life like Dalton. Be nice until it's time not to be nice.
Right.
Yeah. Well, and Speaking of, I think that's a good philosophy. Some people just have it in their nature that everything's a fight. And maybe that's how they psych themselves up to represent their clients. And it's fine. But I remember, Will, when he was at Thompson Co., he was on his way out. It was well known that he was on his way out. And we had one case together that it was very tough liability for me. And he called me up and said, hey, I'm handing this case over. I'm going to make some calls. You guys are going to go mediate and try to work this out. But he's like, I think it's prime for you to go mediate this case and go get it resolved. But he did that on his way out. And that, that was a lasting effect. And that's how I think part of the reason I reached out to him is just we became friends because of that. But it's just, he didn't have to do that. He could have said, you're on your own. But going sometimes just a little bit extra helps keep that relationship. And
as someone that switched sides, reputation in this town matters.
Yes.
I'll say that. It matters a lot.
Yeah. And it seems like you did it all right, huh?
Yeah. Question real quick. I probably know the answer. Do you talk to jurors after trials?
100%. Every single time.
Really?
I will always stay, even after 300 plus, because I learn more from talking to them afterwards than I do. I mean, I remember one of the first trials I had, they poured out the plaintiff and was talking to him afterwards. And they're like, well, we didn't believe him. And I go, well, why did you not believe the plaintiff? Well, he said he couldn't afford any medical care, but his son, who didn't testify, was there and he was wearing the brand new Air Jordans. And those cost $400. So we knew he was lying because he could afford $400 shoes for his son and said he couldn't get treatment.
Wow.
And it's
amazing what they focus on.
They are so focused on things that not that I even do. I mean, normally I want negative feedback. Like what did I do wrong that I can improve on for the next one?
Are you going to change if some jury you're never going to see again tells you they didn't like the tie you're wearing? Or they didn't like your attitude, or that you were too mean to that expert
Absolutely,
doctor?
I would consider it. I mean, I would take it into account because I want the next jury to not have that same issue. So any attorney, and I've met quite a few who are like, oh, I've tried enough cases. I don't care what the jury say.
I never talk to a jury, ever.
Because
I'm fearful of them telling me something that I changed, and that one person that one day is the only person on earth that cared. And I only need 10 anyway.
Right.
So,
but I'm the exact opposite opinion. I always do because I want the feedback. I want to know what they liked, what they didn't like, what they wanted to know, what they didn't know. And so I'm of the opposite opinion, which is fine. I mean, it's just,
I think more people subscribe to your philosophy on that, which probably means I'm in the minority and probably wrong. Maybe I don't want to blow to my ego. You stink. Really?
Well, I've been told before, like, hey, on a case that I won, they're like, you're a dick. And I was like, okay. I was like, well, why do you think that? Like, well, you just kept hammering on the plaintiff and pointing out all their lies. I'm like, well, yeah, that's my job. And so again, take it with a grain of salt, but it's feedback that
I get permission in voir dire to be tough on witnesses. If I find that it benefits my client to be tough on that witness, and making a hold it against my client if I'm tough on that witness. Yeah. And I kind of get permission on the front end.
Well, that's one of the things smart. I do in voir dire also is not being tough, but explaining to them, if I object, if plaintiff's counsel objects, don't hold it against my clients, where I kind of laid that foundation during voir dire of don't hold it against my client if me or plaintiff's counsel are being pricks. We're just trying to represent our client.
Everybody's a football fan. We all got to throw our red flag every now and then, and we got to get a video review, see who's right and wrong.
So
we the last juror I talked to, they were a very educated jury, like a jury pool. They were 4-year education. Here in Harris County, and it was interesting because I talked to one of them. We had a good verdict on it, and one of the guys was like, I really liked the PowerPoint that Kevin Haynes did, but he's like, why did you choose Comic Sans as his font? And to this day,
that's a fair question. And so to this day, we want Kevin in the comments. 2 things: one, Kevin in the comments. Tell us why you use Comic Sans. And 2, if you got a cool name for the show, please put it in the comments as well. And that goes for everybody watching.
We ragged on him so hard. And it's been 2 years, and we still rag on him. Like, every once in a while, we're like, hey, did you do that in Comic Sans? And he defends himself. He's like, it worked, didn't it? Like, they didn't cost us, but it was just really funny because I was like, that one juror was just like, why Comic Sans? And we're like, I wouldn't have thought about it, but I was like, yeah, why Comic Sans?
Yeah. Well, and so to your point previously about tech and PowerPoints and everything else, the case that I tried against these gentlemen, they had all of that. They had the PowerPoints, they had the visuals, they had all the high tech you could possibly imagine. But at the end of the day, they didn't believe the plaintiffs.
Mhm.
And so I think it really does depend on, will it hurt your case? Not at all. I don't think technology would hurt your case by presenting things in an easier manner to jurors. But I don't think that it's going to help if they don't believe your client.
It sounds like the client is the plaintiff is usually the make or break situation, which is fair. Have you tried a case where the plaintiff didn't bring the plaintiff, or the plaintiff wasn't there?
Yeah.
How did that go?
Not well.
Not well for you or the plaintiff?
No, for the plaintiff. I mean, if they're not going to show up for trial, they're not going to win.
Yeah.
I mean, it's that simple. And without getting into politics, I've seen it a lot this year of plaintiffs who were not documented refusing to show up.
Yeah.
Because they're terrified of being deported.
Which, that's a thing in itself, you know.
But that gun kicks as hard as it shoots. We've got clients that don't want to talk to us because they're not, documented, and they think it's all a setup. And so it works for both sides. And so
it's unfortunate, but yeah, putting that aside, I mean, there's certain things where you see, I've heard a lot of recent times where plaintiffs aren't bringing brain injured clients, or plaintiffs' attorneys aren't bringing brain injured clients because it's so difficult for them to be on the stand.
It's traumatic. And that's a different scenario of somebody who's just not going to show up
for a back injury or for spine injury.
Well, if your client doesn't show up, do you just stip to liability or admit liability and try it on damages since they're not there? Or does juror care?
It depends on the facts, but normally if I don't have a client show up, I'm not going to trial.
Really?
Why? You're going to lose. You can't, in my opinion, you cannot win a case in front of a jury without a client there, absent a valid reason. Now, I have tried cases where their elderly can't be there. That's a different scenario. But if it's in their 30s and 40s and I can't have a valid explanation of why they're not there, no, I'm not trying that case. I'm calling the carrier and saying, give me more money, settle it. I mean, the same scenario came up last year.
Because you're stuck on a cooperation issue too, because you can't sell your client out to the insurer.
I can't tell the carrier that my client's not cooperating, because that would be a violation of their policy, and therefore there wouldn't be coverage. So,
and you're the client's lawyer.
I'm the client's lawyer.
Pull coverage real fast.
And so whenever I call and say I need more money at trial, I can't tell them why. And so it's a catch-22. Now I've got a good enough relationship with most of them that if I call and say I need more money, they're going to give it to me.
Yeah. I know we're probably wrapping up here soon, but one of the things I did want to ask, when you get a file put on your desk, you don't just pick it up and say, I'm trying all these cases until they tell me not to, right?
I just got one yesterday, and I'm not going to say the carrier's name. I said, y'all screwed up big time. I go, y'all blue stowers. You're going to pay close to 7 figures on a $30K policy because of how bad you guys screwed up. Yeah. And the reason why we have so many files though is because we're honest with them. We don't say we're going to try everything. Anybody who does that's an idiot.
Yeah.
I mean, you have to evaluate every case because every case is different, and you've got to be able to make the tough phone calls and say, look, guys, this is a bad one. You're going to have to put money on it to settle it. I've settled one case on the courthouse steps in my entire career. And that was because my client presented great in his depot, clean cut, retired guy, plays golf, shows up at trial, and he looks like a homeless Jesus. I'm like, dude, what happened? Like, he gained almost 100 pounds also. And he goes, well, my appendix burst. It got infected. I've spent the last 6 months in the hospital. Jeez. And he just looked horrible. And so I had to make the tough phone call to the carrier and say, look, I need more money. Here's why. And so it was an expensive lesson, but now we have to ask. I have the male attorneys ask the male clients and female attorneys ask the female clients, has your physical appearance changed since you were last deposed or since we last met? And it was a tough lesson, but it's one that we learned.
Yeah.
But to answer your question, no, we don't have the mantra, and I know that's not what the plaintiff's bar thinks, or HTLA or TTLA. They think, oh, Shane just wants to try everything. That's not accurate at all.
And that's the reason I asked that.
There's a risk dynamic.
Yeah.
The insurer is going to have a risk dynamic, which my experience would have been, there's a demand that's made, there's a report that's written, What's the difference between this? Is the gulf too big to resolve? If the answer to that's yes, that's what jurors are for.
And, Grim and I both spoke along with, Josh Lee and, Garcia from Jim Adler's office out in California at the Houston Bench Bar Conference last year with all the judges. And we had the data. We literally have the spreadsheets. We track everything. We showed them out of the 100+ jury trials we've done since COVID, our last offer was $4,600 less than what the jury awarded. So we were off by less than $5,000 of what we were offering to settle the case. The plaintiff's last demand was off by over $187,000. And so we were trying to explain to them, every judge goes, well, why don't the insurance companies just pay more money? It doesn't matter. Even if we'd offer the additional $5,000, their demands are so high that it's irrelevant. And so we're trying to stress that, look, we're not trying to be unreasonable. We're pretty close to how they're valuing the cases.
And there's a big difference between personal lines and commercial lines, right? And are we talking personal lines here?
Personal lines,
okay.
Yes, not commercial.
Yeah, and that's fair. It's just I just wanted to make that difference.
Commercial lines versus personal lines, totally different scenarios. And so we excluded anything on the commercial line from that spreadsheet.
There's a lesson for the defense too. I made this. You're talking about how people appear at trial. Zoom depots have destroyed an opportunity to size up certain people, and that we did Zoom, even post-COVID, Zoom depots of a really nice lady who had a burn injury on her hands, and we had the medic, and we had some photos, and it was like, she's a different, she's got injury. We tried the case. She walks in. First thing I did was, oh no, that's Exhibit A. And you couldn't size her up in a screen on a Zoom deal.
No.
And she was messed up and could barely walk and had all these, comorbidities. And it was call my carrier, not my client at that point, and say, hey, by the way, price of poker's changed. And let me tell you why.
Right.
And it was the very similar scenario you experienced. So, the lesson learned, be careful with sizing people up just on Zoom.
Are you taking Are you taking a lot of depositions still, or are you doing more just trials?
I'll take some expert depots, but fact witnesses, parties,
your
normally
team.
not.
Yeah, your team.
I got a great team. So
yeah, that's awesome. I mean, you worked your way up, and you're with a phenomenal firm. I know we talked to Dale a lot, and so
that's what's so funny is that most people don't realize that Dale Jefferson represents almost every plaintiff's firm in Houston for all their legal malpractice stuff. So yeah,
alleged legal malpractice.
Always alleged.
Yeah.
So no, I've got a great firm. It's a great group of partners, and I've been offered exorbitant amounts of money to go to the other side. And I love my firm. It's our motto is faith, family, firm, and that's how we treat everything. So
it's great. Is Wayne Pickering still there?
Wayne retired.
Yeah.
Yep.
I had a tire blowout case with him. He represented one company, but he was. He would always pick up the phone and just call me like, Omar, how's your day going? Yeah. I just wouldn't put you out the case. And so I have a really soft spot in my heart for Wayne. And then he had that bad tennis injury, I think, right?
Yeah.
Multiple.
Yeah. So,
well, Shane, thank you so much for being our very first guest.
Well, thanks for having me, guys.
Has a podcast name come into your mind in the last hour?
Put it in the comments.
I've been thinking about it a lot. And
the last hour
for the last
you can tell he's a good trial lawyer.
And my initial thought is 3 against 1, because you got 3 plaintiff's attorneys against 1 defense attorney. I imagine that's going to be the scenario.
Not always.
That'll be the episode name.
No, yeah.
That'll be the episode name is 3 against 1.
All right. So that's the episode name. I've still got to ponder and think about a very good podcast.
Hey, we went pretty easy on you.
I don't disagree. I appreciate all the questions.
We want your insight. I mean, I think it was great.
Yeah. So
we don't know each other well enough yet to be able to take the jabs.
Right. Yeah. So maybe that'll be episode 100.
Yeah.
So
that'll be that beer after trial.
There we go.
Yeah.
Exactly. So no, thank you guys for having me. It's been great. Enjoy the questions and just enjoy being able to speak with just all candor and help out young attorneys who are up and coming and give them some insight.
Yeah.
So
thank you, Shane.
All right.
Thank you guys.